Welcome to part 2 of the TechTainment series on Small and Gutsy. Just a quick recap about TechTainment. TechTainment began about 12 years ago and is dedicated to exploring one of the most important intersections shaping our future: technology, entertainment, and the law, and all of things that come together under those topics that actually impact all of us. One of the panels I'm most looking forward to at this year's TechTainment conference, which is on October 16th, so get your tickets, explores a topic that influences virtually every area of our life because it's about disputes and mediation. Whether people recognize it or not, there is an impactful issue within that context, and it's implicit bias. Most of us, I have to say, confuse that term. When people hear the word bias, they often assume it refers to prejudice or intentional discrimination. But that's not what implicit bias is. Implicit bias is a normal part of how the human brain works. It's a mental shortcut that helps us make decisions when we're faced with incomplete information, limited time, or uncertainty. These automatic associations shape how we interpret situations and respond to them, often without us even realizing it. In other words, implicit bias isn't a character flaw, it's part of being human. Understanding how implicit bias operates is the first step toward recognizing its influence and making more thoughtful, informed decisions in moments that matter most. My guest will chime in when I introduce her, but this isn't in the case of an emergency. But we all have our own vantage point and our own lens. And very often we're looking at something through the only lens we have. And so teaching ourselves to consider options from different vantage points is incredibly useful. I use it in my teaching in graduate school. Welcome to Small and Gutsy, the podcast spotlighting nonprofits and social enterprises with budgets under $10 million. My name is Dr. Laura Scherck Wittcoff, and I'm excited to be your host. We bring you the lesser-told stories of organizations that are bold, passionate, and making a real impact. Perhaps you will find needed services, a job, volunteer, invest in, or donate. Small and Gutsy is more than a podcast. We're a 501c3 nonprofit, and we've recently been ranked number 8 on FeedSpot's top 30 social impact podcasts, and number 3 and number 9 by Million Podcasts for the top 30 volunteer podcasts and for our youth empowerment episodes, respectively. We're proud of these honors, but we're prouder still of our mission to elevate the visibility of small but mighty change makers. Do you happen to know a nonprofit or social enterprise doing incredible work? Send them our way to laura@smallandgutsy.org. The challenge is that our legal system depends heavily on judgment calls made under uncertainty. Whether you're a judge, lawyer, mediator, executive, or business owner, you're constantly evaluating credibility, assessing risk, predicting outcomes, and deciding what is fair. Mediation provides a unique opportunity because, unlike litigation, the process itself can be intentionally structured to help participants recognize and manage unconscious assumptions before those assumptions influence the outcome. That becomes especially important in entertainment and intellectual property disputes, where there often isn't one objectively correct answer. So, consider the kinds of questions that arise in these cases. What makes a creative work truly original? You often hear, especially in my organizational development industry, like it's repackaging. So I find it with a slightly different spin on it. So I find these questions really fascinating. They came from my guest. What makes it commercially marketable? What feels authentic to an audience? What creates consumer confusion in the marketplace? These are not mathematical questions. They require judgment. And wherever judgment is involved, unconscious assumptions can quietly shape decision-making. For example, and I'll give you one, and my guests will give us many more. Independent and under-resourced creators often lack the financial ability to register, protect, or aggressively enforce their intellectual property. As a result, their disputes may receive less attention or be perceived as less significant simply because they don't have the resources that larger companies do. I'm sure there are many, many more examples, and that's why I am so excited about this year's session at TechTainment conference. I really hope that my session isn't at the same time. As I was telling Tricia before we started recording, I really want to go to hers. So the goal ultimately is not to eliminate bias completely, because that's neither realistic nor possible. The goal is to recognize that these mental shortcuts exist, design processes that reduce their influence, and make decisions that are more thoughtful, more informed, and ultimately more fair. My guest today will also hopefully, I'm not going to let her do all of it because I want you to come to the conference. We'll discuss some ideas about strategy. TechTainment will benefit you because you will learn so much from her. You'll get to hear her on a panel and meet her in person. That's what I'm excited to do. So that's one of the reasons I'm excited about this year's TechTainment conference. These conversations aren't just about artificial intelligence or emerging technology. They're about how we make better decisions as professionals and as people while technology continues to reshape the way we work. I am so excited to introduce my guest today, Tricia Schafer, a full-time, and I love this word. I hadn't heard of this until I read her bio, a full-time neutral and former litigator with 31 years of experience involving all aspects of commercial controversies. She is known for connecting people and concepts to outcomes that transcend the sum of their parts. I love that. Tricia mediates cases nationwide, both privately and through the American Arbitration Association. And I didn't tell this to Tricia when we met briefly before the podcast, but I actually took a class on mediation series as a therapist, as a social worker, and I thought it was incredibly interesting. So welcome, Tricia, to Small and Gutsy. I'd love to know both about the panel and what you're hoping to accomplish at TechTainment, but I'd love for you to start a little bit, because you've generously given your time to Small and Gutsy, a little bit about how this came about, because there are lots of people doing mediation. Some are not attorneys, and I really love the word neutral. When I saw that in your bio, because you think of litigators as tough people and really going to go after stuff. And when I saw yours and it said neutral, current neutral, former litigator, I thought, oh my gosh, this woman knows exactly what she's doing and how to help other people. So welcome to Small and Gutsy, Tricia.
Thank you, Laura. It's a real pleasure to be here. It's a great introduction to TechTainment as well. And yes, you will learn hopefully a little bit from me in TechTainment, but more importantly, we are going to learn from each other. And I knew that from the minute I set foot in TechTainment. Fun fact, I went to TechTainment by accident a few years ago because I had a conference nearby and a friend of mine was involved in TechTainment and said, hey, come out a day early and come to this conference. You won't regret it. And he was absolutely right. And so I ended up becoming a loyal follower of TechTainment. I am an Arizona lawyer, and to step foot, even though it's held on an Arizona State University campus in Los Angeles, I only knew my friend. And by the time I left, I had about 24 new friends. And it really is a collegial group of senior, very experienced, seasoned folks like have already been interviewed on this podcast, as well as law students, as well as younger lawyers just starting out, or younger neutrals. I love that you picked up on the word neutral. It is a noun in our profession. There are lots of us who use it because neutral is kind of a catch-all, because in addition to being a mediator, I'm also an arbitrator. And so it's kind of a mouthful to say mediator and arbitrator. So I just kind of say neutral. It's a private pay way and also a secure way to resolve your disputes outside of court. Now, I do some court appointed work. I volunteer with our court system in both civil and probate matters here in Arizona. And then I do some reduced hour work for certain organizations, certain nonprofits here in Arizona. But then I do have my standard commercial approach for both mediation and arbitration. As an arbitrator, I work with the American Arbitration Association. They send me cases. I do commercial matters, real estate matters, healthcare matters, and consumer. But today we are talking about technology and entertainment law in the mediation context. So we're going to be talking about my particular panel, or the panel that I'm putting together is speaking about implicit bias and heightening our awareness of that.
I think it's amazing. I have a couple of quick questions. One is I love your background because it's so rich and gives you I think, the ability to understand so many different contexts, which I think is really important. When you do arbitration, is it sometimes binding and sometimes not? And do people have a choice when they go in?
I have never done a non-binding arbitration. That's one of the double-edged swords of arbitration is generally there's no right to an appeal. There are certain grounds, like if you could prove that the arbitrator was flagrantly biased, in other words, taking money on the side for something. I mean, it's got to be pretty flagrant. And we're required to do a lot of disclosures about companies that we're involved with and invested in and all that. But as a practical matter, arbitration is binding. So the kind of the quick and dirty way is arbitration is known for being quicker and you get the benefit of picking your neutral. You get to pick who decides your dispute. And now it's a mutual process. You have to kind of you have to decide with the other party, but
Right.
you can pick someone at least who has experience in the area. For example, if two parties have a dispute, an environmental dispute, if you file it in court, you may get a judge who has done family law for 20 years and just got on the civil bench and she's going to be like environmental versus with the American Arbitration Association and a lot of the neutral providers, you could say, hey, we want an environmental lawyer who is now a neutral, or we want an engineer, or we want a water lawyer sort of thing. And so those are the pros of arbitration. The cons, I guess, if you want a second bite at the apple, is there really is a very limited right to appeal. Another con, if you will, is that you do pay. You do pay the hourly rate of your neutral. But on the other hand, it's private. It doesn't become public record.
So there's benefits on both sides. Yeah. Okay.
Yep. Mm-hmm. And then I also serve as a neutral with FINRA. A lot of us hear of FINRA associated with financial institutions. Those are securities arbitrations involving broker-dealer relationships, involving employment of brokers at financial institutions. And then I just got approved to be a mediator for the United States Postal Service for their employment matters. We'll talk in a moment about different types of mediation: facilitative, distributive, and transformative. The postal work is going to be transformative, which is going to be really fun.
That's really interesting. Wow. I had no idea.
Yeah.
It's great. I used to do employee assistance program work. And so I used to work around employee relations issues. So it's interesting as a social worker therapist and as a consultant. So I find those cases so fascinating. So I'm not sure where to start. I want to focus on TechTainment and what you're going to deliver and why it is so important for this conference that they invite you to talk about implicit bias. So I just mentioned one example, but I think you have a plethora of examples of where implicit bias can interfere with our decision making. And I just want to say one other thing. I really appreciate the fact that you said this is part of how our brain works. Because the minute you start fighting against what is natural, you've stopped raising your awareness about it and you're pretending it doesn't exist. And that doesn't help anybody. So I love that you framed it in that way. So what are some other examples so folks can understand of where implicit bias plays a role in sort of the legal system or where you might have a whole series of cases or questions?
Well, keeping in mind, we're all humans and we all form judgments every single moment. I mean, if I'm sitting here looking out my window and a Mercedes pulls up versus if into my driveway versus, a beat up pickup truck, I'm going to make judgments about the person in the vehicle before I even see them. And because I'm just sitting here talking with you and I will likely not interact with either one of them, it doesn't really matter. Where it starts to matter is if I do interact with them or if I do help them resolve an important dispute in their lives and start really kind of leveling the playing field in order to get to the meat of the controversy. I used to think it would be so cool, and there must be software out there that will do this, or you could probably make AI do it in a secure setting where, typically before mediation, you get position statements from each side as to what they want to accomplish in the mediation, kind of an ideal situation for them. And even on that, it would be nice if you could just strip the law firm letterhead off because you don't want to make judgments about the law firm associated with the client. Even just give them fake names because you may make judgments on the ethnicity of someone's surname.
That's true.
The little subtle things in that regard. I mean, there's a reason why employers, when they're trying to reduce bias, they don't want your picture on your resume because they want to judge people based upon their merits and their criteria. And I mentioned earlier position statements, a key factor of mediation. And this is where bias, you can start removing bias even in this simple exercise. There's a difference between positions and interests.
Yeah,
and
that's what I remember
mediators
learning.
know. I mean, this is mediation 101. Anybody who's taken mediation in college or high school has probably understood this. And the classic example is you walk into your kitchen, you have two kids standing at the refrigerator fighting over a single orange. It's the last orange in the house. And they each want the orange. And your temptation as a parent is to take out a knife and cut it
And
in
split
half and
it.
give them each a half orange. Well, that might not make them happy because we know that it's better to ask each child why they want the orange. And you may learn that your son wants to eat the inside of the orange because he's hungry and thirsty. And you may learn that your daughter wants to do a science project with the
Right. The
rind of the
peel.
orange.
Yeah.
And
Yeah.
so you could make it so it's a different way to make people happy. And so that's a drill that we do very early on in getting to know the parties in the mediation, is to find out, okay, we know what the law is, we know what you say you want, but let's dig down deeper. What do you really want? Do you really want money, or do you really want the security of knowing that you can keep the house? And perhaps there's another way to do that by giving the money to, another party with a commitment to pay the mortgage or something like that. I mean, there are all sorts of things you could do
That
to parse
satisfies
out.
that.
Yes, yes.
Yeah.
And that exercise in and of itself starts stripping down. And then you can say, and it works really well in Zoom too. It's like, okay, room A wants this, room B wants this. And it's easy to do it that way. So I hope that's somewhat helpful.
Yeah, it's a great example. And it brings me back to the course that I took, which is so funny. And it's really about what do you want versus what do you need. And it's just such an interest versus position is this is what I learned, you'll correct me, but a position is immovable, whereas an interest is movable. So when someone takes a position, it's hard to wiggle them if you don't dig deeper and say, what do you really need or what do you really want out of this?
Well, people can move their positions. I think the position is, what you say you want, and then the interest is why you want it. And then you have to dig down as to what is it that you really want.
Really want.
And so it's a kind of a different way of thinking it. But yeah, you can get people to change positions, but then you get into, if they reject an offer, you want them to make a counter offer to keep the conversation going. And you may have someone who holds, answers no to the same question all day until towards the mid-afternoon. Like, are you willing to give up the Mercedes? I keep coming back to the Mercedes. I've never even had one. But I mean, in the probate litigation
Right.
and probate mediation, people are fighting over people's stuff. And let's say everybody's figured everything out except they're fighting, and the Mercedes is the last thing. And one person's like, no, 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 I'm not giving it up. I mean, no can always change. No simply means I'm not going to change my position based upon the available information.
That I
And
have
so
right
as the
now.
mediator, you're always trying to find new little tidbits. You're like, oh, okay, well, if you're not going to give up the Mercedes, well, what would happen if the other room, said that they would assume, I don't know, half the mortgage on the house, or that they would get rid of the motorcycle, or that they would be willing to put a lien on something, or, remove a lien from something. I mean, there are lots of little levers that can be pulled and lots of tools in the toolbox, because if you learn that room A really wants the Mercedes and room B is simply holding on to the Mercedes for leverage and they don't even want it.
Yeah, that's good information.
It's because a lot of people hold on to things that they don't want purely for leverage.
Of course. They may feel they don't have anything else, which is I think it's so fascinating. And that is true, my guess, in the entertainment and technology world. So if we get back to techtainment, where do you see both mediation, but even implicit bias playing out in that context?
I mean, let's take an example of, the big elephant in the room about AI's role in shaping content. And, there are going to be disputes about how AI is used, about in contracts with creators, about whether they could use AI, or contracts with creators that will allow them to create independently. and not be, booted out by AI. There are certain biases regarding the amount of time it takes a creator to do certain work, and could it be done more efficiently with AI? Well, I mean, that's a bias, but on the other hand, what's the work product like? And how do you know for sure that you're getting original work? Another common factor with bias is even just, analyzing the marketplace. I mean, making judgments about, okay, well, where is this content going to be streamed in? What's the market that we're going to be targeting? And making assumptions about what that market wants, about what that market will pay for, without sufficient information, without consulting with people who, live and work and breathe in that marketplace. There's often a disconnect between the big, smoky rooms where decisions get made versus the people on the street who are actually listening and watching and streaming and digesting the content.
Yeah, it's so interesting because we do make these rash decisions sometimes based on what we like, almost a confirmation. We seek that evidence that confirms, like confirmation bias, what we want to know or want to see. So that's sort of a tricky thing in that space because people are, also vying for similar kinds of be able to use information or use data that may be full of bias or and so then they're, making the case that, oh, you should go this direction or that direction. And so in that context, people can waste a lot of money.
Yeah.
You're smiling. So share with me about that.
Yeah. I mean, just a matter of, whether you fund priorities without doing sufficient research, whether you don't fully listen to your stakeholders about things that matter to them. I mean, so much of dispute resolution is dispute prevention. And that is so key, particularly in the technology world. And I guess to pivot for a minute, let's focus on entertainment for a minute. I mean, just that is shifting so rapidly in terms of content type, quality, and what people are demanding and the formats they're demanding. And I mean, even just looking at the music industry now versus even just 20 years ago, the way, creators are paid, the way it's streamed. I mean, nobody's buying albums anymore. I mean, it's totally different. And staying ahead of that technology and doing the research in the technology, and then also understanding who is going to be affected both at the creator level and the investor level, and even the time horizon for music and digital content to generate revenue is so different than it was 20 years ago. And so that needs to be factored into deals, and every deal, every contract, this is why they have big legal teams at all these technology and entertainment companies, is that they really need to vet exactly what is going to happen in this particular instance, and to place heavy emphasis on not if, but when there are disputes, how they're going to be resolved. It's very common now to put mediation clauses in contracts. Because there's a real benefit to at least taking a good faith shot at resolution before you start spending tons of money on the adversarial process.
It's interesting because it certainly exists in my field. Mediation is often part of a contract when you're working with someone, either from a psychological perspective or any. So when I sign up in a school contract as a professor, there's a mediation clause, which I think is interesting.
Yeah, importantly, I think a lot of people don't realize that you can negotiate those. Now, if you're buying a car and they hand you a 12-page contract as DocuSign, blah, 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 you're probably not going to be negotiating that in kind of a consumer contract of adhesion. But in a contract involving personal services and a contract where your talent is being secured to perform certain tasks, when you get your contract and you're reviewing it, I mean, that could be an important part of the negotiation. And you could say, look, yes, we want to mediate before we arbitrate or before we litigate, but what does that mean?
Yeah, good question.
Are we going to do it for 1 day? Are we going to for 2 days? What type of mediator are we going to get? Are we going to get an entertainment lawyer mediator? Are we going to get a mediator that's going to cost me $1,000 an hour, or are we going to get like a court-appointed mediator? Where are we going to mediate? Are we going to mediate in person? Are we going to mediate on Zoom? And are we going to do so in good faith? And if so, what does that mean? I've had cases where, and these cases are not ideal, where you have an unrepresented individual mediating against a company and I'm the mediator, because you have to be
Wow.
careful to have the unrepresented person not leaning on you too hard. But I do, in my engagement letter, explain what good faith mediation is. And that varies for each case. But to really lay out the expectations for how the parties resolve their dispute, how soon, how much time you can allow yourself to mediate, maybe a 60-day period to pick a 2-day mediation as a good faith effort to avoid litigation.
Yeah, I love that. So I'm wondering, does this ever happen where before let's go back to entertainment and technology, before something is signed, they do have a mediation clause, I get that, but do they ever hire someone like you to come in early, just in the discussion point, so that you can be involved in supporting the infrastructure, not the signed contract per se, but the infrastructure of so that the parties understand that mediation is part of the deal in a way. Like, does that make sense?
It does. And yes, I'm sure there are neutrals who serve that role. I haven't served it officially, but I do speak on this a lot to trade and industry groups and to bar associations, so they know kind of what to look out for and how to draft their clauses. Typically in putting together a deal in the entertainment industry, each side will be represented by counsel. I suppose in a matter where a party can't afford counsel, they may be unrepresented, but hopefully they can lean on someone. But yeah, I think to bring in a neutral during the contract negotiation phase to help provide language for what dispute resolution would look like. That said, some of the larger national providers or international providers, there's GAMS and the American Arbitration Association come to mind. If you go to their websites, they have sample clause language. They want you to go to their website. You don't need to be a member.
Yeah.
You don't need to be a member. You don't need to pay. And it's like on AAA, it's called Clause Builder. And so you go to Clause Builder, you pick your language, and then you can finesse it and negotiate little pieces of it. But to make sure you don't forget the key parts, you can even name your mediators. And particularly if it's a small geographic region, let's say Los Angeles County. And I know that's funny. I say Los Angeles County is small, but it's a big country. So let's say you decide you want to handle all dispute resolution in LA County, and you name 6 mediators that you would be willing to consider, when the time comes. And assuming they are middle-aged to, senior, they will likely still be alive during the 6-year period. And then they know that they're in the hopper to be potentially included. Now, if it's some 20-year deal, you might want to be careful who you name, because somebody might retire.
Right.
But it's nice to have at least some sense, because it really is not if a dispute will arise, but when a dispute will arise. You will always have a dispute with contact. Always.
Wow, that's such a, both realistic and a little depressing, like that but I think it's human. I think it's human nature, which is what you're talking about. So what are some of the key strategies that you're going to share maybe at the conference? Just a few. I don't want you to share everything. When you are considering, when there are issues around intellectual property, or you're looking at a contract, or what are some of the strategies to manage that implicit bias that might be presenting your way? And I'm thinking that along with maybe someone who is not as savvy, who's newer and younger, and doesn't necessarily have the benefit of full legal counsel. What are some of the strategies to look for specifically about implicit bias, whether it's technology or entertainment?
Well, you mentioned the panel, and there's one spot we're still filling, but I am co-presenting with my longtime friend and colleague, Maria Crimi Speth. She is a partner at Jaburg Wilk here in Phoenix, and she's going out with me to LA, and she is a classic intellectual property lawyer. I'm more of a Jane of all trades. Maria has built her career in intellectual property, and she is now a hybrid litigator and neutral. I'm all in as a neutral. She still brings both perspectives. So I know that Maria is going to have a lot of interesting, very specific war stories from her own practice about what she has observed in the intellectual property world. And so I don't want to...
no, don't step on her toes. I'm
not going to step on her toes, nor am I going to even predict what she's going to say. So, but she's a very good speaker. She's going to be amazing. And then as for me, the way I would answer your question about strategies, particularly for people who are either younger or less experienced in the area, I think go in, not defensively, but going in and kind of look in the mirror and kind of think, okay, what do I think they're going to think about me? In other words, kind of stay ahead of the bias that you're anticipating. If you're a low budget creator with a lot of talent, I mean, you can't change your income, but I mean, you dress like the job you want, put your best face forward, total professional, wear a suit, all the things, wear whatever's, appropriate, and try to stay ahead of that bias. Also, because as you noted, Laura, in your introduction, the word bias kind of has a negative connotation to it. If you say, well, I think you're biased, then someone thinks they're prejudiced, and then, everybody gets defensive. So we want to avoid, unless we're in an enlightened community of people talking about implicit bias, you don't want this to pop up in a job interview or pop up in a contract negotiation. But there are subtle ways that you can stay ahead of it and anticipate it when you think that you are going to be negatively affected by bias. On the flip side, if you are the money party, if you are the corporation, if you are the entity, if you are the Netflix and the Amazon and all the things, realizing that you need to check your bias in the sense that statistically what your audience wants, numerically and monetarily where the money comes in, where the ad revenue is best, and all the things. But that said, you don't really know what's going on in people's heads. You don't know why they're watching what they're watching. And so realizing that it's your decision who you deal with, but it's not really your decision. You're really trying to cater to your audience and to remember that, particularly in entertainment, you get loyal followers for reasons that you don't even know.
True. All true.
And so follow the trends, follow the data, but also build a team of decision makers that has a variety of perspectives. Another fun thing, and I have done this, I do this actually a lot to prep for my mediations. I will completely dumb down the fact pattern and give everybody a fake name and type. Maybe I'll spend half an hour with Claude AI and just type the scenario into Claude, and I'll change the whole scenario. Instead of, Mr. Jones and Mr. Smith fighting over a commercial building or whatever, I'll say, Bob and Larry are fighting over a pickup truck or something. I'll just make it totally different. But the dynamic, it could level it because Claude AI doesn't have a clue,
Right.
who anybody is.
Right.
And so you can do that as a little exercise. And I'm certain that contract review apps and software and platforms, when reviewing applications, when reviewing RFPs, I'm sure there are things you could toggle and, adjustments you can make in the software itself to, potentially strip the names or strip
Control
the birth
for it,
dates
yeah.
or, things like that to make it more even-handed.
I really like that. I liked all of what you said. I think that having some degree of perspective yourself and to pull back and be more an observer in your own process allows you to at least know that it exists and how can you do some predictive thought process in that, which I think is really great. I also wonder does someone ever, especially someone who can't afford it, will someone come in with someone like you, a mediator versus hiring an attorney for a contract discussion? Or does that never usually not happen?
I've never seen that happen. I mean, no one's ever asked me to do that. Because typically the lawyer looks out solely for the interest of their client. And just from a pure budget standpoint, it would probably be cheaper to hire a young lawyer than it would be to hire a seasoned mediator.
Yeah, that makes
And
sense too.
Yep.
It just sometimes feels, I know this is so kind of weird, but it feels like whenever there is a negotiation between two lawyers, and I mean, that's why you're really here, it's adversarial. Like you walk in and it just feels adversarial versus we want the same thing at the end, potentially. It's just how we get there and how it gets resolved. So I find that so fascinating because some lawyers whom I've known, their goal is to keep it going because they earn more money. I know that's not ethically responsible, but sometimes there's a piece of that. Yeah, it happens all the time. It always surprises me. Like, how does someone live with themselves when they know this could be mediated much more easily? But that's sort of a separate thing. But I certainly see that in entertainment and in technology when in people's minds, and this is true, there can be a lot of money on the table and there is ego on the table and there is creative, rights on the table. So there's all this stuff there. So I love that you're at this conference because I think you're going to get a lot of questions and a lot of interest. Both of you will, but since I'm interviewing you, I get to talk to you about it. And I wonder if you'll plant the seed for folks about the concept of implicit bias, because it does operate, and it operates often in a covert way. So sometimes people won't know why they're being treated in a certain way. They just feel it. And so raising that kind of awareness, I think, is so helpful for more of the newbies, somebody who hasn't been around the block. But even those of us who have can sometimes get into that uncomfortable space.
Yeah.
So I really appreciate that. So what are your hopes for people who are coming to the conference? What do you want them to walk away with from your session, from your piece of it? I know that you're working with, you'll be with
Yeah. Well, the panel and I look forward to a lot of questions with people sharing their experiences. And I guess if there was one thing I would want them to walk away from is that bias is not bad. I mean, bias is not negative. And to kind of flaunt your bias. I mean, at least flaunt your awareness of your bias. And
absolutely.
to be more, I guess this is kind of a weird analogy, but 15 years ago, people weren't saying, "Oh, I went to a therapist." "Oh, this is, I'm
Yeah,
really
so
focused on my mental
true.
health. I'm really
Yeah.
focused on my mental
Yeah.
health." And
Right.
similarly, I mean, how many of us were using sleep trackers 20 years ago, unless we
Yeah,
thought we
so
had
true.
legitimate sleep apnea? It's like, I
Right.
mean, if I went to the office in, 2005, it's like, I slept 8 hours last night and I'm so
Right.
rested. People would be, well, how many hours did you
my
bill while you were
my
doing that?
aura ring, right. Or my aura
Yeah,
ring
with my
said this
work.
about me today.
Yeah.
Yeah.
Yeah. And I
Yeah.
think right now, because we did have that pretty awkward period during COVID where there was this huge corporate emphasis on diversity and inclusion, and then that kind of got morphed into bias. And, it's okay to talk about bias. It's okay to be biased. And if we could just kind of flaunt that we know we have biases, then, I live for the day when a mediator could say, "You know what? I feel like I'm getting a little bit biased from this room. I need to go take a 5 minute break." I mean,
I love that.
maybe.
Like, well, how can
Yeah.
you get more
Yeah.
human than
Yeah.
that? And you know
Yeah.
what I mean?
Exactly.
So
Yeah.
I
Yeah.
love that you're
Yeah.
I would say
Yeah.
normalizing it.
Normalized bias.
Right,
Yeah.
which is
Yeah.
such a great opportunity for people to
Yeah.
recognize it. And the other thing is,
Yeah.
when you pretend it doesn't exist, it creeps up
Yeah.
anyway. You're not going
It
to
does.
stop bias just because you pretend
Yeah.
it doesn't exist.
Yeah.
So
Yeah.
naming it and raising awareness allows you to make good decisions about how it's going to impact the process or you personally. So I love that. And what are you looking forward to at the conference? I know your panel, but outside of that, what are the areas that sort of pique your interest in this, entertainment, technology, and law combination?
Well, I do have a secret to share.
Oh, okay.
I don't have a television. Uh, I don't
Uh,
watch movies. I, I
oh,
read
wow.
the Wall Street Journal, the New York
Yeah.
Times, and I listen to podcasts. So I look forward to like learning current events on what movies are out there, just because I don't.
Yeah.
I struggle with fiction. I'm not a fiction person. For me, fiction is a real commitment, and it's got to grab my attention right at the get go, or I'm not there.
Or
So
it doesn't
I look
happen.
forward actually to learning what I've been missing out on,
I love it. That's great.
and also learning from the younger folks. I learned so much from the younger folks, the law students, the younger lawyers, about technology tricks and devices and strategies. But when I went to TechTainment for the first time in 24, that's when the name, image, and likeness in collegiate athletics was just becoming a thing. And I don't have kids. I don't have kids in college. I don't even think about colleges anymore, other than, if there's something in the Wall Street Journal or New York Times. And so to just learn about that and that aspect of sports law and how that impacts the athletes and the universities, and just, the high school kids with their Lamborghinis at the prom and all
Yeah.
stuff. And
It's a little
and
scary.
now it gives
Yeah.
me a frame of reference to when I do read the newspaper online. I'm like, oh yeah, that's that. So it exposes me to areas that I would ordinarily be unfamiliar with. I love interacting with the California audience because I'm doing more in California now, even though I'm still based in Arizona. So that'll be exciting. And just just the camaraderie. It is such a welcoming environment. Even from the very first, when you check in with the staff, they are just a real pleasure to work with, and from top to bottom.
I love that. I think the networking aspect, and that's what we've heard time and time again, is such a valuable piece. And you mentioned it earlier, and it's so true. I think it's really interesting that you don't like fiction, so you like nonfiction, I assume.
Yeah.
And yet the work that you do, even though if you think about sort of the legal aspect is fact-based, your entire work is not necessarily totally fact-based. It's really much more in human nature. So I love that. And people bring in fiction to you, I'm sure, when they tell a story. It is a lot of fiction, or it can be. So I love that it's not something you gravitate toward, and yet your professional life is filled with, and maybe it's about, here comes my therapy moment, maybe it's about cutting through some of the fiction to get people to really recognize what their needs are, the reality of their needs and their desires and their wants. So I think it's great. So I'm very excited about this conference. I'm very excited about your session. And I'm so looking forward to, we've only met online, so I'm really looking forward to networking with you in person.
Likewise.
But I've appreciated this conversation on many levels. And I want to encourage people to come to the conference to get some strategies from you. And I love the fact that you really appreciate the students, the young folks, the early entrepreneurs, and the early, law students that are really trying to kind of jump into this pond and figure out a way to swim, because it's complicated. And I love that people are, curious and interested in wanting to use both tools and wanting to use the ideas that you are preaching and teaching that will help them navigate some muddy waters at times, I think. So I love that. So what is at the top of your wish list for TechTainment? But the answer can't be money or funding, because every nonprofit would want money or funding. It's like too easy of an answer.
Sellout attendance and a diverse audience.
Perfect. I love that for so many reasons. Yeah, love that. And it's kind of sad because currently diversity is not seen as a positive in so many arenas because of administration, and it's such a huge positive. I teach a graduate class, and I do a group. It's a group-based class. It's like a lab. And when students are forming groups, I ask them to not, as much as possible, don't be homogeneous, because you're going to have a Band-Aid response to a social issue that you have to present, and you won't necessarily think about other perspectives if you don't have people who don't look like you in the group. And then you can always find that if you happen to have a it's your homework. But it's a really good lesson in my lens is only one way, and I need to really find people who have a different perspective. So if you were to think of a song that describes TechTainment, what might it be? It could be a lyric. It could be a lyric if it wasn't a song.
Come As You Are. I think it's a Peter Gabriel song from the 80s.
Oh, I love that. Come As You Are. That just came out of, I think that's great. Come As You Are. You're going to learn a lot. That's great. I love that. And what do you think makes TechTainment gutsy? Because they're on Small and Gutsy. What makes TechTainment gutsy?
Or was it the Jay Giles Band? I'm going to have to Google that.
We may have to have an edit. That's okay. Come As You Are is the song. I love it.
And I'm sorry, what was your third question?
What makes TechTainment gutsy? Because they are gutsy. What makes them gutsy?
Oh, wow. No, I mean, it is a very high energy, innovative, non-traditional forum. I mean, I have been going to conferences in the legal setting since 1994. Okay. When I walked into TechTainment for the first time in 2024, I knew instantly this was going to be a different experience. This is not your typical legal conference. I was welcomed instantly. I actually found someone who had the same undergrad that I did, and we bonded, and we're still friends, and blah, blah, blah. And I mean, it was just instant, the warmth that you get from that room, because people are there because they really want to be there. And then I remember some of the sponsors bring students over from Arizona State, and they're on the plane together. They're just kind of bonding, and it's just such a nice audience. And in fact, I'm still struggling. I haven't booked my flight yet. I haven't figured out if I'm coming out the night before, because number one, nobody wants to be in 6 p.m. LA traffic trying to get to LAX. But number two, you want to stay as long as possible because there's always somebody to talk to.
Right. And they sort of did it this year on a Friday, so people might stay for the weekend to enjoy LA if they want to, or if they've, connected with someone. So I love that. I think they are definitely Gutsy, because 12 years ago, they were really out of the box thinking about this. And now there's a lot of AA conferences, but this really stands out. And I'm really impressed and proud.
Yeah.
What do you think, and I don't know if you'll be able to answer this question, but what is something that maybe outsiders or even a few insiders don't know about techtainment?
That it exists. I mean, I had not heard of it before, and I guess just getting more visibility out there. And the fact that it is technology and entertainment and how those are combined. Because you could have entertainment law seminars, that focus on just that, and technology, that is what it is. But I mean, the fact that this is held in Los Angeles kind of says it all, because, they do bring talent from Silicon Valley. They do bring talent, from the LA area to kind of bring it all together. And so knowing that law students can attend, knowing that, you can attend and not know much about technology or entertainment at all and come out of it with information that is high content, good quality, but also digestible enough that even if you're not steeped in that discipline going in, you still understand what's going on. I was super impressed. The first time I attended, they had folks from the Patent and Trademark Office that have flown out from DC. They have government folks. So you've got your public sector, you've got your students, you've got your private sector creator side, consumer side, and then you've got your private sector corporate side, talking about trends in the industry. And there's going to be so much to talk about this year with AI and the shifting economy and just kind of the uncertainty associated with this administration and what's on the horizon for, there will be a different president in 2 years. It may be similar or different or whatever, but it's going to be different.
Right.
It's going to be different from what we have now. And just are we going to be working in an environment where, government is more involved, less involved, and how that interplays is going to be a big shift.
Right. I think so too. I think you've framed it so perfectly that people don't really realize there's something for everybody, that it really isn't just it's not legally focused only. In fact, that is just one component. And that they do bring individuals in from the public and the private sector. Because I was at that conference too, and I thought it was really good. Because now these governmental entities are going to be given directives about what's considered intellectual property and the whole AI piece, what's original work, so on and so forth. So it is going to get more and more complicated. It's so interesting because it just keeps progressing, and I find it just personally. We were laughing today on when I had done the other recording with Mark and Conrad, that we were kind of laughing because someone had sent me a picture of two people. One I knew, the other one was just a friend of theirs. And I said, "Oh, was that friend with you at that place?" And they're like, "No, they just used AI to put the superimpose a picture."
Oh my
and
God.
you literally couldn't tell that it was not real. So there's so much of that, and it just becomes harder and harder to decipher. So that's when you bring a mediator in to help sort of think about that to an extent. Although a lot of people who do that kind of work don't want to admit that it isn't legit. So that's a whole nother ball of wax. Hopefully we'll get smarter and smarter at trying to figure that out. But at the same time, I think people who want to manipulate are going to get better and better and better at doing that as well. So you're going to have both sides of that equation. So it is what it is. So I can't wait to learn from you, to listen to your session. I want to digest a lot of the strategies that you have, because I think you can use them in everyday life. I don't think that they're strictly for someone who's in entertainment, law, or technology. I think in everyday life, we're negotiating all the time. And to recognize our own biases are not bad. They're just biases, and we have to raise our awareness about it, I think is just so key. So I just want to take a moment and thank you, Tricia. It was just a pleasure to have you on Small and Gutsy as part of TechTainment. And I will ask you this, how do people reach you? Because you've given your time, and if someone does need a mediator, I'd like them to think about contacting you. So if you're comfortable, how would folks find you?
My website is adr.financial, financial. You could also do triciaschafer.com, but there's a lot of different ways to misspell that. So my URL has several ways to reach it. But yeah, adr.financial is the easiest way to reach me. And honestly, my SEO is pretty good. So if you spell my name correctly and type it in Google, you'll see me pretty quick.
That's great. And I will put your contact info, your website, in the show notes too.
Very good.
So
Very
we
good.
will see each other October 16th. I hope you see plenty
Excellent.
of other people.
Yeah, for sure.
I just want to thank you for taking the time out of your busy day to sort of hang out with Small and Gutsy and talk about this conference and the work that you do. It's great.
It's an honor, Laura. Thank you so much.
Thank you. Please go to smallandgutsy.org to check out all of our episodes. And if you're so inclined, please purchase some Small and Gutsy merchandise, consider sponsoring an episode, or making a donation. Both are tax deductible and help keep us going and spotlighting these great organizations. The opinions and viewpoints expressed by our guests are independent and don't reflect the position or views of Small and Gutsy. Of course, we can't take responsibility outside of our own vetting of the organizations we interview, so before you sign on to support or work for them, we encourage you to do your own due diligence and research them as well. I want to thank my partners in this endeavor, the Intrinsic Group, the donors, the sponsors, and my incredible board of directors, Brianna Carmichael, John Gatto, Lucy Mello, Ari McCoy, Melissa Greitz, and Serena Rajabian, who believed in me in this project enough so to sign on to support this effort, and all the folks, friends, and family who have guided and inspired me. And thank you for listening. Together, we are spreading social impact, and you can help us. If you like this podcast, please share it with your friends. And don't forget to email me the name of any organization you feel would benefit from being interviewed. From small and gutsy to big with impact. I'm Dr. Laura Scherck Wittcoff, and thanks for listening.